People of the State of Michigan versus Germaine, Raymond. These are files 1922912, where he was convicted of delivery of methamphetamine as a habitual criminal third offense, which is a felony punishable by up to a maximum of 40 years. He also was convicted of possession of methamphetamine as a habitual criminal third offense in file 1922913, which is punishable by up to 20 years. And in file 1922913, he also was guilty of driving while license suspended, denied, or revoked, which is a misdemeanor punishable by up to 93 days. And he was placed on adult drug treatment court probation for those cases. And while on that probation, he has been convicted of yet another drug offense, possession of methamphetamine as a habitual criminal third offense in file 2023354. And in that case, he is represented by Mr. Sopanos, and in the other cases, he is represented by Ms. Yancey, and Mr. Gabriel is the prosecutor. And Mr. Raymond is appearing from the St. Joseph County Jail by video. Ms. Yancey, does he have any objection to continuing by video from the jail?
No, Your Honor.
All right, so with that, we'll do the probation violations first, and then we will address the new charge. All right. Now, in these cases, as I said, he pled to a charge of delivery of methamphetamine as a habitual criminal third offense, a felony punishable by up to 40 years, and possession of methamphetamine as habitual criminal third offense, a felony punishable by up to 20 years. The agents prepared a probation violation report, and corrections are needed to be made in those. In terms of jail credit, the correction should show that for file 1922912, in the last entry, he was arrested on March 1st, 2021 on the new probation violation, and no bond was granted, and so therefore he has 84 days credit from March 1st, 2021 for a total in that file of 209 days credit. In file 1922913, he has an additional 81 days for March 1st to May 21st, and the total in that case is 199 days. Is that correct, Ms. Yancey?
It is, Your Honor, but on the first file, Your Honor, you did say 84 days, and I know it was 81.
Oh, 81. I can't even read my own writing, so it's 81 days.
Confusion for my client.
Okay, 81 days in both cases between March 1st and today, and so with those, the totals are correct. 209 for the first file and 199 for the other file.
Correct.
Any other additions, corrections, or deletions?
No, Your Honor.
Okay, Mr. Gabriel?
I have nothing, Your Honor.
All right, so the agent's recommending sentences of 108 months to 40 years in the first case, credit, and then 24 months to 20 years on the second case with credit for days served. Ms. Yancey, what would you like me to know?
Thank you, Your Honor. Mr. Raymond entered adult drug treatment court as a part of this sentence, and with that, he had to plead to everything that he was charged with. While he was in the program, he completed IOP, he completed Helping Men Recover, he did motivational enhancement through community mental health. He also did his MRT at the Twin County Probation Center, and then went to some individual counseling. He did get independent housing. And then in March, and he gained employment, excuse me. In March, when everything shut down because of COVID last year, he did get laid off from his job, but he had actively been working. And then he was able to get employment again in December of 2020. And he was still working there until he was arrested end of February of this year on the new charge. He was in a suspension mode during that whole time from last summer. And because of that, he couldn't have any new services unless he did those on his own. And we all know that it was very difficult to get any kind of services because of COVID. People weren't meeting in person, and things like that. But he was able to get on housing with a friend, and he, like I said, he was able to get employment again. If we look at his guidelines, Your Honor, just on the minimum, without all of the habitual, the score is obviously lower. It's that tail end that's higher because of all the habituals that led to everything in charge. He is getting sentenced later today, Your Honor, on the new charges. The agreement was that they'd run concurrent with this PD. I know that he did ask for a specialty court from the prosecutor's office, and that was denied. But I would ask Your Honor to consider, while he did struggle with the program, there were many things that he did make some changes in his life for. He was one of our older participants, and he has children that he is engaged with, and he is asking Your Honor to consider an even lower end on the sentencing guideline, and he's asking that could we at least sentence at the same guideline level as the new charge, based on the work that he did do in ADPC.
Okay, thank you. Mr. Raymond, this is in terms of only the probation violation cases. What would you like me to know in terms of these?
I am ready to own up to my usage and my charges that I have, my new charge that I have. I would like to apologize for wasting the court's time for coming back and forth into your court with the same charge. I did struggle with use of meth, and sitting here in jail for these last 3 months, I've come to realize that I am an addict and I do need help.
All right, thank you. Mr. Gabriel?
Your Honor, the courts established these specialty programs under certain guidelines with certain intents. The prosecutor's office is involved in the gatekeeping process because of the fact that a successful completion of that program results in a total dismissal of the charges. Obviously, when we go along with or, accept that opportunity, we know what the ramifications of it are, and I'm confident, knowing Ms. Yancey and knowing the court and having been at various drug court programs, that the participants know what they are. The taxpayers provide significant opportunities for people with addictions. First of all, to deal with the addiction. Secondly, to actually be able to wipe out a significant criminal conviction. I realize that it's induced primarily by drug usage, and certainly the idea that the government is trying to do everything it can to help its citizens address that problem is a worthy cause. But to the same extent, those individuals that don't follow the rules, that in fact engage in the same kind of behavior that got them into the program in the first place, have to have serious ramifications if the program's going to continue to function. I just want to make it very clear to Mr. Raymond, and I know Ms. Yancey knows this, the swift and sure is something the court makes a determination on. There may be some legal prohibitions that might be pointed out by the prosecutor, but I don't recommend people for that program. I don't have any role. If the court chooses to do that, that's another option the court has. And then, of course, I could address the court if the court's inclined to do that. All being told is when we give somebody an opportunity to wipe the slate clean and get help, and they commit a new crime, I mean, it's time to go to prison. It's time to do the time. We all know that in most practical situations, whatever bottom line number this court gives to a prison sentence is going to be when the pro board is going to let a drug offender out, as long as there's behavior in the institution. So I think we have to address that. And the guidelines were significant, but he knew they were significant when he accepted and asked to be in the program, and when he availed himself of his choices to find a different way to get by versus, I don't know. I mean, I keep hearing all the time about people would rather get unemployment than work. Maybe wasn't available. I don't know. I just know that we have to back those people making the recommendations that are also supervising the people in the program. So I'd ask the court to follow the guidelines.
Thank you. Mr. Gabriel makes a ton of good points there. You know, you enter into this program for drug court with the realization that you're pleading to all the charges as written. And because if you successfully complete the program, everything's dismissed as if it never happened. It's taken off your criminal record. It's wiped away. The convictions are wiped away. We have an assessment that you go through with Dr. House, where it's explained to you the requirements of the program and what's needed and whether you're interested or not. And you know, the thing that she says when we begin every time is that the one thing you have to change is everything. You know, we don't take people into the program that have no problems. They have to have a substance use disorder. They have to be committed to the program. And I spend time with you when we enter into the program, explaining that to you and making sure you understand it, and that you understand that if you don't do it, here's what's going to happen. If you do it, here's what's going to happen. And so he was put into the program, and it was a struggle from the beginning because he denied that he had a problem with substances, to the point where we said, you know, if you don't have a problem with substances, maybe this isn't the program for you. I mean, it was always, I don't use, I just sell. Well, okay, we thought you used, which was reflected in the fact that while on probation, on February 7th, you had a positive for methamphetamine. You got 1 day, credit 1 day. On February 13th, you had a positive. You got 3 days, credit 1 day. On January 21st, you tested positive. You got 14 days. January 21st, 2021, you got 14 days, credit 2 days. And then on March 1st, you were found to be in possession of methamphetamine, and that's where this final violation comes from. It indicates that on June 9th, Three Rivers Police conducted a compliance check at Germaine Raymond's residence at the request of the Department of Corrections. They found a female in the bedroom with you. The canine walked and alerted to a box. It was very cluttered with shoes and clothes. They searched the bedroom, and the meth pipe was found. There was another meth pipe. The box also contained baggies consistent with drug packaging. Inside a cabinet drawer on the bottom floor, or on the bedroom floor, several empty packages of THC edibles were located. They alerted to both vehicles in the driveway, one that you had rented, one to your guest. No contraband was found. Question about the pipes, said they were his, but they were old. Admitted that when he used meth, he smoked it from pipes. He then went into detail about how he had been selling drugs for some time, and it was difficult for him to survive without. The agent briefly looked through Mr. Germaine's phone and found evidence of drug deals. The phone was seized and sent to MDOC, found evidence of drug deals and stolen property, and it was forwarded to law enforcement. He was then taken into custody on the probation violation. He was arraigned on the probation violation, and then, later, after he pled in the other case, these cases were resolved. It says under the agent or the probationer's description of the violation, he was questioned during his arrest on June 9th. He admitted to his agent in front of the police that he had made some sales because he hadn't been working, but he said he hadn't sold any drugs since last month. Germaine was interviewed again at the jail on 4/29/2021, and he stated that he had taken advantage of the pandemic, knowing that he wasn't being tested as frequently. He stated that he was addicted to the lifestyle that came with drugs and then got caught up with using. In regards to the felony contact, Germaine stated he doesn't know why John Paul Lewis was contacting him about a gun, and he denied having contact with Alex Zunick He stated he believes it was Amber Carpenter who was contacting him at that time through Alex's Facebook account. He appears before Your Honor for sentencing on a probation violation from 2020. He was suspended from the program, decided that he needed to be terminated by the team due to his new conviction. He made minimal progress on probation. He failed to maintain full-time employment throughout the majority of his probation. He tested positive for methamphetamine numerous times and often lied about his use in an attempt to delay the outcome of any court-issued sanctions. He failed to really dig into his recovery or utilize the resources provided to him. Germaine did not often reach out to peer support or seem to really build healthy, strong relationships with others on the team. He has been arrested for possession of drugs twice since his placement on probation. He admits that he has a drug problem, but denies still dealing in the streets. However, it's known among most that he continues. He has had many opportunities to get his life on track and learn what it takes to become a law-abiding citizen, but instead he took the ADTC program for granted. He was a participant for almost a year, but his criminality hasn't changed. It's unclear at this point what it will take to change his behaviors, but it's the belief of this agent that he needs to be removed from the community. So, in the first case, the guidelines to the charge of delivery of methamphetamine as a habitual criminal third offense, the guideline range would have called for a sentence of anywhere from 72 months to a high of 180. In the second case, 1922913, his guideline range was 5 months to 34 months. So in file 1922912, on the charge of delivery of the controlled substance methamphetamine as a habitual criminal third offense, probation is hereby revoked, and you are sentenced to get where these recommendations are. So this one, 1, 2, 2, 2. Sentence at the bottom end of the guidelines, 72 months to 40 years in the Michigan Department of Corrections, credit for 209 days served. All outstanding fines and costs are still owed and due and payable. In file 1922913, sentence of the court that you be sentenced to 2 years to 20 years, credit for 199 days served, and this will run, both of these cases will run concurrent with each other and concurrent with the new charge. In each of these files, you'll be provided 3 forms advising of what your rights on appeal are. I'd ask you to sign 1 copy in each file. If you wish to appeal, you need to fill the rest out, return to the court within 42 days. And those will conclude both of those cases. So, those 2 are done. And now we'll go into the other new one. Now in this case, Mr. Raymond in file 2023354 is charged with possession of methamphetamine as a habitual criminal third offense, and he is represented by Mr. Sopanos. That's a felony punishable by up to 20 years. The plea agreement was that the sentence will not exceed the amount in the probation violations and will run concurrent with those probation violation cases. We have just finished the probation violation cases. And so in this case, Mr. Sopanos, do you have any additions, corrections, or deletions to the pre-sentence report?
No, Your Honor.
Mr. Gabriel, do you?
No, Your Honor, I do not.
All right, and in this case, the agent recommends the prior record variable at 110 points level F. offense variable 0, level 1, guideline range 10 to 34.
No objection, Your Honor.
No objection, Your Honor.
All right, and so I intend to comply with the plea agreement. What else should I know, Mr. Sopanos?
Nothing, Your Honor. All I ask is that you take into consideration the plea and agreement and sentence accordingly.
Thank you, Mr. Raymond. Is there anything you'd like to add?
No, Your Honor.
Mr. Gabriel?
No, Your Honor, whatever the court.
Okay. I'll follow the recommendation of the Department of Corrections. In this case, 2 years to 20 years in the Michigan Department of Corrections, credit for 114 days served, and there is a $68 state cost and $130 crime victims assessment. Again, in this file, you will receive 3 forms advising you of what your rights on appeal are. I'd ask you to sign 1 copy acknowledging that you received them. If you wish to appeal, you need to fill the rest out, return to court within 42 days. All right, that concludes all the cases, and we will now go off the record.